Hi folks, I'm Greg McLawsen, the Affidavit of Support lawyer. I help green card holders litigate federal lawsuits to enforce their rights under the USCIS form I-864 Affidavit of Support. And I was flying home yesterday when I received a decision we've been waiting for in a case in California. This is the Central District, which covers Los Angeles and Orange County. And it's a really helpful decision, obviously to my client, but also to other green card holders out there. So wanted to cover a couple things that came down in this decision from the federal court and talk about what the implications might be for other folks. So again, this is federal court in California, Central District out of Los Angeles. This particular court is in Santa Ana, right outside of Los Angeles. And there are basically two main decisions that came out of this particular decision. Number one is that we have another federal court holding that affirmative defenses do not apply in lawsuits to enforce the Affidavit of Support. Okay, what does that mean? When you bring a lawsuit to enforce a contract, so let's say I hire you to put a new roof on my house, and you don't do it right, and so I sue you for breach of contract. I say that you promised to do this, you didn't do it, and you owe me XYZ money. An affirmative defense basically says, yes, you're right that I breached the contract, but there are excuses that prevent me from being liable. Even though I breached it, these affirmative defenses basically say, yes, but. Yes, I breached the contract, but I'm not liable for XYZ reasons. Federal courts have pretty consistently held that those excuses do not apply in lawsuits to enforce the Affidavit of Support. And this decision yesterday is one more in that line of cases. So the defendants in this lawsuit, there are three of them, set forth 13 different affirmative defenses. These include things that we see all the time, like fraud. So basically the allegation is, hey, this person never really loved me. They didn't marry me for legitimate reasons. They married me for a green card. We see that allegation all the time. The court said, no, that allegation, even if it's true, even if you could prove facts that show that somebody had bad intentions going into the marriage, that's not the case here. But even if you could prove those facts, it is not a legal defense to liability, nor are other defenses which would usually apply in contracts. So unconscionability is one of them. If I enter into a contract with somebody and it's so completely unfair and ridiculous that reasonable minds would just, the head would spin off the body, it's so unfair. Courts say we're not going to get into that analysis with the Affidavit of Support, period. So all 13 of these defenses out the window. We are just not going to talk about them. This is really, really important because what it does is focuses the Affidavit of Support litigation specifically on the allegation that's made by the plaintiff. So my client says, I got the green card based on the Affidavit of Support. My income has been under 125% of the poverty guideline. The federal court says, that's what the case is about. Not about any of these 13 different excuses that you, the defendants, can come up with. We're not going to talk about it. We are going to be laser focused on, did the immigrant get a green card? Has her income been under 125% of the poverty guideline? That is it. So it massively focuses the case. That makes it a much more streamlined process for the plaintiff to go from bringing the lawsuit to getting it reduced to judgment. This is, again, a decision that's consistent with others out there in the federal court system, but every time we have a new court, a new federal court that gets on board with that line of reasoning, it's a really significant step towards the next time we bring a case in a new jurisdiction, we can say, hey, judge, it's not just the courts in North Carolina. It's not just the courts in Washington. It's not the courts in Northern District of California. Here's another decision by the Central District of California that also reaches the same results. So it's really quite accurate to say at this point that federal courts have consistently taken the view that we saw yesterday, which is that no affirmative defenses, no excuses. That was number one in the decision. Number two in the decision is that we asked for attorney fees for having to bring that motion. Now, before you say, hey, that's about the lawyers, if I have a case, I don't care about whether the lawyers get paid or not. Stop for just a second, because here's what this means in reality. There is an attorney fee provision in the statute governing the affidavit of support. The way that attorney fees provisions typically work is that at the end of a lawsuit, now without an attorney fee provision, everybody pays their own legal fees. And that might mean $100,000 or $200,000 out of pocket if you're talking about federal litigation. But if, as is the case with the federal statute here, if there's an attorney fee provision, it means that if a plaintiff brings a lawsuit to enforce the affidavit of support and they win, the defense has to pay their legal fees. Now, usually that happens at the end of a lawsuit, and that might be a really long process. So we've had cases going on for a year, 2 years, and at the end of all of that, the plaintiff wins and she gets her gets her attorney fees. Well, then that is often the first time that the defendants wake up and they say, oh my goodness, this is really expensive. Well, their lawyers should have been telling them that all along, but I can tell you that doesn't always happen. Instead, these defendants have been going along on the misguided belief that they are going to win their lawsuit, which doesn't happen. And at the end of it, then they realize they're on the hook for $100,000 for a lawsuit that they should not have been fighting in the first place. What we did in this motion was we said, Judge, look, we respectfully think that the defenses that are being raised here by the defendants are just not based in law. You know, at this point, there are enough federal decisions out there that defendants in these lawsuits should understand, and their lawyers should understand, that you can't raise these affirmative defense excuses. And the fact that they did this and they made us, the plaintiff's attorneys, go through all this trouble to file a lawsuit. I'm based here in Seattle. I had to fly down to Santa Ana to argue this case. Since they made us do that, they need to pay for those fees now, not at the end of the case. They forced this expense onto the lawsuit. Congress has told us that defendants are responsible for these attorney fees and they should pay them now. And the judge agreed and awarded fees for this motion. The reason that's important is not because I get paid. The reason is that the next time defendants out there in one of these lawsuits want to, it doesn't cost them anything, they say, well, we'll just make these 13 or 20 different excuses about why we're not liable under this contract. The next time they do that, we will point to this case and we will say, you got to withdraw these defenses now. Or number one, we're going to go to the court and ask the court to dismiss the defenses, which we expect will happen because that's what all federal courts do. And number two, we are going to ask the judge to impose on you, the defendants, the cost of making us do that work. And you're going to have to pay it now. So that will make the defendants experience that pain earlier in the lawsuit and face the consequences of their ill-informed defense to the lawsuit sooner than later. So that's a very helpful precedent because it makes the defendants wake up earlier in the litigation process and realize, whoa, this is going to be expensive. If I am going to continue to fight this, attorney fees are going to continue to mount, and I'm going to have to end up paying that at the end of the day. So hopefully that has a enlightening effect on future defendants of the world as to when they want to be serious about talking resolution in these cases. Because on the plaintiff side, we are always, from the very first time we raise a claim against the defense, we are telling them, please come to the table, please talk to us about a resolution to this. As the plaintiff's attorney, I would much rather see this thing resolved out of court and have my client get paid earlier in the process. The only thing that happens as the litigation compounds is that the fees go up and it gets more expensive to resolve the case. So the sooner we can do it, I've said this in plenty of videos you can find on the channel, the sooner we can do it, the better it is for my client, the plaintiff, because they get paid, they can go on rebuilding their life, and the better it is for the defense because it will be a less costly resolution if we do it sooner rather than later in the process. Just finally, in terms of the impact of a decision like this, again, this was in the Central District of California, governs Los Angeles and Orange County and areas around there. Decisions that are handed down by federal judges on the district level as opposed to circuit level decisions, which is the next step up where cases go to be appealed. District level decisions are never legally binding on other judges, but they have a persuasive value. In fact, in this very case, that was the very first question that the judge asked me out of the gate at oral argument was, what do I do with the fact that there are these decisions in other districts? And the answer to that in a nutshell is, yes, Your Honor, the other decisions are not binding, but when we have judges all around the country coming to exactly the same decision on this issue of affirmative defenses and excuses to liability, when all of the federal judges are coming out the same way, that is a really strong indicator that the federal statute is correctly read in a particular way. There are certainly some areas of law where judges are all over the place and judges come to all sorts of different decisions about the same legal issue. But when we've got a bunch of, they're called Article 3 judges appointed by the president with the advice and consent of Congress, when we've got all of these judges doing the same thing, that's a really strong indicator that the statute says a particular thing, and that is the law, not just in that area of the United States, but throughout the United States. And I think we really can now plant our flag pretty firmly on the proposition that there are no excuses to liability. This idea of affirmative defenses doesn't exist in the arena of the affidavit of support. Hope that's helpful. Again, my name's Greg McLawsen. I do these cases on behalf of sponsored immigrants all over the United States. If you have questions about the affidavit of support, feel free to jump into the comments. If you believe that you have a potential case to enforce rights under the affidavit of support, reach out to me at soundimmigration.com. Happy to do a remote consultation for you. Be well and